10 seconds, 5 seconds, start. Further, the first part of section C of the Act appointing the father as the natural guardian has been whittled down by judicial decisions to such extent that it is now disregarded as being mandatory, thereby resulting in the same almost never being applied in practice. The rationale behind such juridical action has been the furtherance of gender equity, no discrimination on the grounds of sex in the appointment of a natural guardian. The proviso to section 6A is subject to the same rationale, that is, it arbitrarily, without reasonable cause, makes a discrimination in favor of one gender to the detriment of the other, which may be termed as nothing short of judicial hypocrisy to strike down one part of the section and leave other part rest standing, especially when the latter suffers from the same ailment as the former. According to the plaintiff, the defendant failed to receive the said sum of rupees 40 lakhs, while according to the defendant, the plaintiff was never willing and ready to perform his part of the obligation and was never ready with the balance of the sale consideration. It is an admitted case of the parties that the sole defendant in the suit is not the sole owner of the property in question and has only 1/5 share in the property in question. For reasons best known to the plaintiff, he has opted not to implead any of the other co-owners as defendants in the suit. As claimed by the plaintiff, even if the sole defendant was the attorney of the other co-owners, still other co-owners ought to have been sued, maybe through the attorney. Non-joinders of these necessary parties to the suit is of some consequence, which of course would have to be adjudicated during the course of the trial. The contention raised on behalf of the defendant, based on the order passed by the civil judge, is that the present suit is barred under the provisions of Order 2, Rule 2 of the CPC, as well as the principles of constructive res judicata. The other objection taken by the defendant is that the plaintiff has sued on the basis of a receipt dated 28th May 2004, wherein the total sale consideration is 23 crores, and while claiming the specific performance of the suit, the plaintiff has valued the suit for the purposes of court fee and jurisdiction at rupees 40 lakhs. This apparently is an arbitrary fixation of suit for the purposes of court fee and jurisdiction and is a clear attempt to obviate the payment of the requisite court fee. The plaint of the plaintiff, according to the defendant, thus is liable to be rejected. Another legal objection has been raised by defendant. The plaintiff filed the suit before the court of the learned civil judge. The plaintiff did not even pray for specific performance. Another aspect of the matter which cannot be ignored by the court is the real intention of the plaintiff and his bona fides in relation to the performance of his obligations arising from the receipt dated 28th May 2004.